let's talk about some drafting techniques. Okay, like I mentioned in the beginning, please. So when you take a precedent, okay, don't Google or just don't take some draft from Google. It's very dangerous. We don't know why they have drafted certain clauses, whether they are negotiated or not. There are certain websites which are paid, which provide for precedents, and there are certain free websites. The free websites I don't know, but there are certain books which I can recommend to you, and I can share it with you guys later. Those books have proceedings of various contracts, and they've been written by very renowned solicitors and lawyers. So if you buy those books, they'll be available on Amazon. You can keep reading those drafts. But if you notice in all of those books, one thing is very prominent, that all of them draft contracts in a very simple manner, right? So please, even if it's a complex transaction, you can still make it very simple in terms of drafting. You don't have to make a drafting complex. The transaction can be complex, but the drafting need not be complex. Also, when you're choosing the draft or precedent, say even from say you're working in a law firm and you choose a precedent, make sure you're choosing the right precedent. For instance, a precedent could be Indian or English law governed document, right? But your contract is say US law governed document or India law governed document. Then you can't use a document that was drafted for an English law governed contract, right? So governing law, before you choose a precedent, check what is the governing law of that contract. Okay. When you're drafting, start with complex clauses, because such as termination, indemnity, limitation of liability, payment clauses, especially if the payment is going to happen in tranches or subject to certain conditions, right? Not only because it takes a lot of time, also because on those complicated or critical provisions, you will require a lot of input from the client. And those inputs you can't take at the last minute. So start with working on, when you start with the precedent, work on the critical or complicated provisions first. Boilerplate clauses, you can leave it in the end, but they're equally important, right? And when you're taking input from your client, don't wait till the end. Important issues please discuss upfront, right? And take inputs in a very organized manner, right? So say collate all your questions in one email and don't keep asking questions in a piecemeal manner, because then the client will think that you don't know what you're doing, right? And when you're drafting, what should be, you keep thinking about when you're drafting, just think that when you're negotiating this clause, will you be able to justify it, right? If you're putting a word or a sentence in your draft, and when you're negotiating, just try to role play and see whether you can justify that clause or that sentence or that statement you made in the contract. If the answer is no, then maybe you need to, redraft it, right? So when you're drafting, just think how you're going to even negotiate it and justify it, so that becomes easier for you to finalize the draft with the counterparty.